Thanks for joining us. Welcome everyone to today's webinar, the California Consumer Privacy Act, Your Questions Answered. I'd like to introduce today's presenter. Joining us is Scott Giordano, VP of Data Protection at Experian. Scott's a highly regarded data privacy attorney with over 20 years of experience. Welcome, Scott. Please take it away.
Absolutely. Thank you all for joining today. I apologize if you hear any bad acoustics in the background here. Every hotel in San Francisco was sold out last night, and so I'm doing this webcast from an old-fashioned phone booth at some B&B. So bear with me if things don't sound quite great, but I will get to just about all your questions. We've got a lot to go through, so let's get started. So what we can do today, I'm going to give you a super quick summary of CCPA because I think you're all pretty well versed with it. Talk about a couple bills that are pending that I think you need to know about in the California legislature. They're going to be game changers. And then we're going to answer as many questions as we can get to. So if I don't get to your question, it'll go up on the blog. And in fact, all the answers that I'm going to give you today are going to go up on the blog anyway. So either way, we'll get you situated. I should have that complete by Friday. And I'll talk about how to comply, at least in my view. Give you some closing thoughts, and that's it. So without further ado, let us get going. So if you leave with nothing else here, if you've been on my webcast before, you know that the GDP is longer, has more words, but I got to tell you, the CCPA is far more complex, just owing to how it was written. It was written in a very hasty fashion, and it reads that way. So we're going to have to make the best of a bad situation. The right to prevent sale of data to third parties is the primary difference. There are other ones that I'll talk about in a minute, but the primary difference between the two is this idea of the right to prevent the sale of data to third parties, and it's just done differently than the GDPR does. So it's going to be a mess, and I'll explain why. Creation or update if you've got a data inventory, creation if you don't. Most important element because you have to know where the data is to begin with, otherwise you're going to be in trouble. So let's go to the next slide and we'll talk about just the summary. I'm going to hit a couple of the high points here. This is effective at the end of the year or beginning of next year, however you want to slice it. But it looks back 12 months. So it looks at the data that you're collecting right now. This is why it's relevant to you now. And it applies to all businesses. They're essentially the same as data controllers, more or less. The collector used personal information. It's not just those companies that are headquartered in California. That seems to be a big mistake people are making. It's potentially subjects the whole planet, quite frankly, to California law, not just to California and U.S. states. So it applies to consumers, which are California residents. This is a rough equivalent to data subjects. It's not the exact same thing, and I'll describe why when I go through the questions. So a couple of rights that you're probably aware of, but if you're not, this is going to be a big surprise here. So right to be informed about what data is being collected, that makes sense. A right to prevent personal data from being sold to third parties in the first place. And if they did sell it for some reason, then the right to tell the third party, don't use it, which again is really, that's great. It's just a strange way of doing things. And yes, there are civil actions the AG can bring. There is limited amounts of actions that private citizens can bring on their own, and we'll talk about how that may change, and that may change everything. So that's it. Let's go to a couple bills pending. Believe it or not, there's about 20 bills either pending or slated to be introduced to the California legislature on privacy. So not exaggerating this. There's a couple here, the first of which is really the only one I really want to talk too much about. That's SB 561. That amends CCPA and allows a private right of action. And so what does that mean? It means that every lawyer in the state is going to be deputized to go enforce this law, not just certain elements of it, but the whole darn thing. And that's a big issue if you're a company, because now you have all these individuals that are coming after you if they perceive that you violated the law. It's going to be a train wreck if that happens, but you need to be prepared. So that's in the legislature right now. There's other bills as well that talk about privacy. One talks about getting the monetary value of the data, personal data that you're collecting, understanding what that is and disclosing what you're selling it for. So that's going to be a big issue if that passes. And then the Smart Speaker Privacy Act, you may have remembered some years ago, there was issues with Vizio monitors. They were listening to people's conversations without their permission, little things like that. They got smacked hard, and so this bill is going to reportedly go and put the kibosh on that. So that's what's pending. I wanted to share that with you guys. There's more, but we'll just stop there. So let's go to the next slide, Abby, and let's dig into your questions answered. These are your questions you sent me. I may have edited it for clarity. Otherwise, it's your questions. So we're just going to fire them off here. And if you have more questions, just send them in. So can you compare and contrast CCPA to GDPR? Yes, I will. Absolutely. There's a slide that we'll just go through the big three things. With GDPR in place, what are the needs areas to concentrate on? Not covered by GDPR. So these four questions really are all about GDPR versus CCPA. So Abby, let's go to the next slide and we'll just hit them. And you can get the big picture of just what the big changes are. So here's three primary differences. Again, you can make the arguments there's more, but these are three that I think you should care about. So one is with the sale or transfer of personal information in terms of giving notice. GDPR, you have to provide notice presumably on your website or however, wherever the point of collection is. That phrase you'll hear a lot, at the point of collection. That's straight out of GDPR. So typically that will come from your website or from your mobile app. So nothing unusual about that. CCPA is a rough equivalent. You'll update your privacy statement on your website or wherever you're collecting the data, and you will essentially say, what information are you collecting? What information is being sold to third parties? And which information is being disclosed for a business purpose? So it's a different way of articulating perhaps a lot of the same information. Essentially, both these statutes have very extensive transparency requirements. I think the big difference is that CCPA says you have to have a link that says, do not sell my personal information on your website somewhere, presumably someplace easy to find, otherwise it's not going to help you. So that's a big difference in terms of sale or transfer of personal data. Second thing is sale or transfer of personal information in terms of right to opt out. That's very sticky. For GDPR, it's fairly easy because you have to have a legal basis, meaning you have to have a legitimate reason to have the data in the first place. And so if you don't have it, then you can't process it anyway. So presumably you've got the consent of the consumer or what have you, or a contractor, or even this funny thing called legitimate interest that we won't get into, but you have to have one of those three, more or less. Whereas with CCPA, you have to give someone the right to opt out, so it's backwards. Unless they're minors, then they get to opt in, but typically you have to give people the chance to opt out, so which is awkward. They probably made more work for businesses than they should have on this, because now you have to set up a opt-out mechanism, especially for your marketing materials. So that's the difference there. It's going to make things, in my view, probably more challenging, not less. And then this whole idea of right to erasure or deletion, you're all familiar with this idea of the right to be forgotten, and you've heard that umpteen times. It's a little bit different for CCPA in the sense that you have to allow the consumer to delete their personal information, but they don't tell you whether it's some or all. It's almost implied the way it's written is that it's all or nothing. Either you flip the switch and yes, or no, you don't delete it all. So I don't know if they'll correct that language because it's vague. It just says you can request that the personal information that's been collected be deleted. Well, does that mean some or all? We don't know. Also, there's really no provision to correct your information, which I thought was really strange. It's either delete it or don't delete it. So it's a kind of a brittle view on this. I don't know if they're going to change that, but that's what you're going to come across. So in theory, there's no right to get your information fixed, just delete it. So don't know what to tell you on that one. That's just the way it was written. Also, there's a lot of exceptions to deletion that I think swallow the whole rule to begin with, but we'll beat that horse to death some other time. So let's go to more questions. Okay. So this is about third parties, and I wanted to call this out separately about third parties because you guys need to know it. There's three different rights you have versus third parties as a consumer, or there's three different responsibilities as a business. So as a consumer, you have the right to tell the business, don't sell your information to third parties, which seems like redundant, but this is part of the law. CCPA says you can tell a business, don't sell my personal information. Then the business that actually sells the personal information has to provide notice that the information may be sold, and the consumers have a right to opt out. So you have this bidirectional communication going on. And then the third party that got the information that probably shouldn't have gotten in the first place has to give you, the consumer, the right to opt out. Now, you may say, well, if I've never had any relationship with this third party, how do they know who I am? That's a great question. Don't know how we're going to answer that. We're in new territory here. So this is the challenges that this regulation has created, or the statute's created for us. But it is what it is. Let's go to the next, and we'll start just burning through questions here. I know you guys have a lot of them. Okay, so unique exemptions for certain entities. So where financial institutions have contractual security control expectations due to the law, How are financial institutions responding? See if they are exempt. This really applies to any situation, not just the CCPA. If a third party says they're exempt, now it's less of a legal issue, more of a political one, because now the question is, do you want to accept their statement, or do you and just do continue to do business with them, or do you want to say, forget it, I'm not doing business with you? I've been in the position in the past of having to drop third-party vendors that did not want to stipulate that they were compliant with certain regulations, and they just said, tough, we're not going to do it. And I said, okay, goodbye. So this is the situation. This is more of a political issue, not a legal one. I think that's the position you want to take if you find yourself with third parties that are not cooperative. How are business associates under HIPAA impacted? How are companies who contract with the state of California impacted? Remember that if you're contracting with the state of California and you've got personal data, California residents, then likely the state of California is going to ask you to comply with CCPA. They're just going to say, even though the state's not subject to it because it's not the government that's subject, it's only businesses, they'll likely tell you that you're required to meet the terms of CCPA. So that's how it's going to impact you there. How are BAs impacted? It's no different in the sense that BAs that are processing data that for whatever reason is not covered by HIPAA. Because remember, there's an exception for HIPAA controlled data. That's not covered under CCPA, nor is it covered under the California version, which I think is CMIA. So those are exempt. But if you have any other information, that's going to be covered under CCPA. So imagine if you've got some kind of a service that is tracking other information, other personal information that's outside, perhaps it's credit card information, then that's going to be something that's definitely going to be impacted. The next question is, if a person from California is a college student outside of California, what responsibility does the college have under the CCPA? This is sticky, and here's why, because this is based on residency. So in theory, if the person from California is no longer a California resident, then the college is not subject to CCPA for any information they gather from that person. But here's the challenge, okay? And it is that suppose they started gathering information when the person was still a California resident. What do you do with that information? Are you subject to CCPA for that? The answer is yes. So maybe the person was a resident in California. When they applied, they gave you all this information. Is that covered? Yes, it is. So any information that is generated after they are no longer California resident is not subject. But the problem is, are you going to create two separate databases for that two different kinds of information? And I just don't see it. So the problem is you're likely going to be stuck with complying with it anyway. Also, this idea of residency is a big issue, and it's ferociously complex because it has to do with taxes, of course. So, and which state gets dibs on you to pay taxes. So that's why this is something that you're going to have to talk to your attorney about, because it's going to be very difficult. Let's go to the next slide. Is there a concise breakdown of the regulations? Yes, we've done concise breakdowns before. I'm sure we've got resources on the website. So I think the answers to the questions will point you to some resources we have that break down the regulations pretty finely, so that you can see the big three changes or big three differences I showed you earlier. Really are things that I think you should direct your attention to first, just because there are differences that could get you into trouble. So I would direct your attention to that first, but then yes, absolutely look at the other breakdowns we'll share with you. I like this question a lot. So I've heard that a copy of a receipt which indicates that Abe Lincoln purchased a coffee and a banana at 1:15 p.m. 4/2/19 at the 7th Avenue Cafe counts as personal data. No other info. So no address, no credit card number, nothing like that. Is that receipt personal data? Well, it's funny that you asked that question, because it just happens to be that information that you're using or that you gather under the Act that is commercial information. So this is covered under the Act. Commercial information, including records of personal property, products or services purchased, obtained, considered, or other purchasing or consuming histories or tendencies. So in answer to your question, yes, it is personal data. Is that amazing? Something that simple. So a great example of how expansive this law is, if you've never read the section that discusses all the different species of personal information, I urge you to read that. That is section 140O, O like Oscar. It has all the different definitions. There's about 20 or so, and it's lengthy. So definitely take a look at that when we hang up here. Next question, how does this law affect DFARS, DFAR 7012 and NIST 80171? So if you're a defense contractor, really any government contractor, but really defense at the moment, then you're subject to both DFARS, which is the rules that the Defense Department sets up to keep bad guys from stealing personal information and really any kind of information. On NIST Internet 171 is the control set. So it's the confidentiality control set. Those of you familiar with NIST know about all the different controls they have. They recommend NIST Internet 171 is the controls for DFAR control data. So the net of it is it doesn't affect DFARS. You're still compliant with DFARS, presumably. You still use Internet 171. You can potentially use NIST compliance to demonstrate that you've got compliance with the CCPA in terms of protecting confidentiality. You still have integrity and availability you have to address, but at least you've got one leg of the triad there. So the net of it is that you still have to comply with CCPA. One doesn't really obviate the other, so you just have to do both. And I've worked with defense contractors that had to do GDPR and DFARS because they were two different audiences, essentially. Okay, next is we're a pure B2B business, so we don't have a business-consumer relationship, but we do have employees in California. How does CCPA affect us from that perspective? Well, bad news is that you're covered by CCPA. So, and that's because Section 140.0, as I mentioned earlier, includes professional or employment-related information. So presumably, you've got a HR system that has professional or employment-related information, which could be just about anything, and you are subject to CCPA as a consequence, even though you don't have any customers. So that's the bad news, if you will, is that that's how expansive this law is. And let's go to the next slide. Types of data that would be under CCPA, so electronic medical records, IDs. Yes, I just mentioned that a couple times now. So when we hang up here, go to Section 140.0 like Oscar. It's going to give you, like I said, about, depending on how you slice it, about 20 different categories of personal information. And it's going to be things that you would not have expected. This is the big challenge that you're going to face, is that it's giving you all the regular personal information you would imagine, like a name and a social security number and a credit card number and all that. But then it's going to give you some really bizarre stuff, like olfactory information. So literally digital and auditory information and other kinds of strange things that have to be reduced to digital format, otherwise they're not going to be very useful. So you're going to find there's all kinds of definitions of personal data that you will just be shocked. And also inferences, gets even better. So you could say that I'm just collecting GPS data, but GPS data is potentially very damaging if you collect enough of it. You can find everything about someone just by that. And you can infer all kinds of things about them. That's personal information. So we've really gone down the rabbit hole here, and it's more of a question of what's not personal information than what is. So, so Section 140 of the law, you have a look at that. You're going to be unpleasantly surprised, I'm afraid. Okay, next up, what kind of data attributes are subject to regulation and the recommended mitigation techniques? So, could the California Consumer Privacy Act apply to child support cases that cross state lines? And this would be where the parent and dependents live in Indiana and the non-custodial parent lives in California. This is a little tougher because if you're the non-custodial parent, you live in California, I'm not sure what data is being processed. If it's being processed in a California court, they're going to be exempt because it's really only businesses. And so if the data is going to Indiana, presumably, that's, again, you're a consumer, but if it's for child support issues or other family law, again, there's an exemption for government entities. So my guess is that it's not going to be applicable in that case. So that's how it would work. In terms of what kind of attributes are subject to the regulation, I just mentioned earlier, Section 140.0 will give you all the different elements that are subject. In terms of mitigation techniques, the short answer of that is collecting as little as possible. And this is all a part of what we call privacy by design. The GDPR calls it privacy by, or data protection by default, by design, or by design by default. It's the same idea. Essentially, collect as little as possible. And I'll give you an example from my own experience. I worked with an ISP some years ago, and they were collecting MAC addresses of the users. And I asked them why were they collecting it, and they said, well, we've always collected it, and we don't know if we'll ever use it someday. That's the kind of situation where you just want to dump anything you don't absolutely need. So that's a great mitigation technique, is just don't collect it in the first place. If you don't collect it, then someone can't steal it or some business partner can't abuse it. We're all familiar with Cambridge Analytica and how they abused the trust they had from Facebook. And so it's a great example. And that wasn't a breach, it was simply an abuse of trust. So a good example there. Next question is, how does the CCPA define and treat data controllers versus data processors? Data controllers are businesses. So if you look at CCPA, you'll find that they use the word business for data controller. And I wish they would have just called it data controller, but they chose not to. They're just calling it a business. So that's essentially the equivalent. Whereas with a processor, you've got really two species. You've got third-party service providers. So if you think about Azure or Amazon Web Services or one of those folks, you have that, and then you also have third parties. So everyone else basically. So they don't use the word processor, they use the word processing, they don't use the word processor. So that's the difference there, is that's the lingo. Most likely if someone's referring to a CCPA entity as a processor, they're likely talking about a third-party service provider. They're probably not talking about, just a service provider as opposed to a third party. So that's just a shorthand, but always double check and get an idea what the relationship is. What are the new rules regarding email marketing? There are no new rules for email marketing. What they do though, okay, this is the challenge here, is that, again, we go to section 140 Oscar, and it lists all kinds of information. And so it's interesting that you're going to find that they're listing interactions with websites, for example. So you think about all the MarTech. If you're a MarTech company right now that you're attending on the phone, or marketing tech or ad tech, or you have a marketing department with it's fairly sophisticated and you're using that technology, all of that interactions that consumers have with that is going to be subject to GDPR. So there's no new rules per se for marketing. It's just that all of that data is now subject to CCPA. So think about all of the network of advertisers that are involved in serving up ads, and how you probably don't even know half these folks because there's all kinds of syndicators that go behind the scenes. Now, all of those folks are essentially going to be brought to the fore because they're part of this ecosystem. And in theory, if you read the letter of the law, the consumers have the right to talk to those folks, even though you may not really have much of a relationship with them. You may only know the first link in the chain. Now all of that has been brought to the fore. So it's a big difference. So if you look at section 140 Oscar, it cites internet or electronic activity information, including but not limited to browsing history, search history, information regarding a consumer's interaction with an internet website, application, or advertisement. That includes cell phones, not surprisingly, or mobile devices, tablets. So here's the challenge, folks, is that's part of scope. And so that means that you have to ask yourself, how am I going to get that information to consumers, or how am I going to strong arm my third parties to get the information to consumers? That's the big difference. If it's going to be a headache for you, it's going to be a headache for everyone. So just be warned, if you're having a sophisticated marketing operation, or even maybe a not so sophisticated one, you're subject to this in a big way. Let's go to the next slide, Abby. So data sharing, data security, outsourcing, and vendor agreements. So a couple pieces to this. I'm going to start with vendor agreements because that's the biggest issue right now, is that it's time to write what I call a dear colleague letter to your vendors. And what I mean by that is that in the run-up to GDPR, I was ghostwriting letters for my clients so they could send them to their vendors. And usually it came from the GC or AGC, someone from legal saying, hey, what are you doing to prepare for GDPR in that case? Today it's CCPA. So really talking to your vendors about what they're going to do, because they have a higher burden than under GDPR, because they have to have this essentially listing of personal data that they're collecting for the consumer and give the consumer an opportunity to opt out. Now, if it's a pure vendor relationship, all they're doing is hosting the data, a la Azure or AWS or any of those things, then it's less of an issue because they're not selling the personal data, they're just storing it or just providing a service for the first party. But still, even those folks are going to have to list with whom they have relationships, or at least the categories of companies with whom they have relationships. It's a little vague. So that's the challenge with vendor agreements, is being able to talk to vendors and say, what are you doing to comply with CCPA? Because they're going to probably either not have heard of it or think that it doesn't apply to them because they say, oh, we're a third party, it doesn't apply to us. Reality is it's worse than GDPR. So they need to come to terms with that, which means a letter needs to go out like now to those folks saying, hey, what are you doing to help comply? In terms of outsourcing, data security, data sharing, we'll talk about data sharing. Data sharing, there's a big issue, and that is that they being the third party with whom you're sharing it, have to understand that they have to abide by the terms of the agreement. They can't do what Cambridge Analytica did and violate your trust. because if they do, then they're in the chain as well, and they're subject to punishment by the state and potentially by a private attorney. So when you work with these folks, it's a good idea to vet them, to get an idea of, are they honest? Are they going to be honoring your trust? If not, you may want to think twice about doing business with them because it's going to be an issue. And in terms of data security, vis-a-vis outsourcing, really getting them to tell you what they're going to be doing in terms of security. This is no different than, I think, 99% of the contracts that we do right now, where you'll list, if you're a third party, you'll list all the things you do. You'll say that I'm an ISO 27K cert or what have you. But you'll do something listing all the different things that you need to do. Which stakeholders do you see will be the real winners and losers in this act in years to come? What if any new local as well as international business opportunities might present themselves? So in terms of stakeholders, unfortunately, in terms of stakeholders that are winners, not aware of any. I mean, this is just going to be a lot of work for all stakeholders. It's another layer of effort. Now, if you want to say that this is going to simply prepare you for all the other laws that are coming down the pike this year, then in that case, I guess you can call yourself a winner if you're getting ready for all those other laws. And there's probably about 15 other states right now that are considering CCPA clones, basically. Also, there's some states that have introduced some new regulations that are above and beyond that. But by and large, by the end of the year, we'll probably see another 15 or so, maybe a fewer than that, but about 10 to 15 states that have CCPA clones. So as a practical matter, if you're ready for CCPA, you'll be ready for many, if not most, of these other laws coming down the pike. And then new as well as local business opportunities. I'll tell you, if you're an expert in data subject access requests, so the idea of helping people package up information and get it to data subjects, you are probably in the best time of your life right now, because it's a big challenge to find data, package it up in a portable format, which both laws, GDPR and CCPA, require, and get it to the customers. So if you're an expert at that, then you've got yourself a great opportunity both here in the U.S. and around the world. Concerns for non-California organizations that may house data of a California resident. Essentially, the concerns are for every organization that's non-California or California for that matter, that they may house data of a California resident. If you house the data and you are a service provider, you're going to have some effort that you have to go through. If you're a pure third party and you're actually using the data, then you're going to be treated more or less the same as the first party from whom you got the data. So it just depends on your relationship, whether you're a service provider or a true third party and you have some autonomy as to what you're going to do with the data. If it's the former, I would still start working with your customers now to give them an idea of what you're doing and preparing for this. If it's the latter, then you've got a lot more work, and it's probably time to bring lawyers in if you haven't already. Next question, do you see the potential of a similar federal law in the near future? How will the new laws affect identity theft? Do I see potential for a similar federal law in the near future? No, I do not. And I do not because the folks in D.C. can't agree on anything. I don't see they're agreeing on data privacy. I just don't. Now, some people think I'm poo-pooing the federal government, but you know what? We're 4 months into the year. Don't see any bills that have any hope of passing, okay? I mean, just because people put bills up there doesn't mean they have any hope of passing, versus states where the states are pushing these things through. Following the one in Washington State, that's my home state, and it looks like it's on its way through getting to the governor. I believe it has to go to conference committee, but we'll probably have the first CCPA clone will be from Washington State. So I don't see federal laws coming down anytime soon, and by the time one does come down, it likely will not preempt state law. Otherwise, you're going to see a big uprising among the states that have already passed these laws, saying, why did we do all this effort if the federal government is just going to emasculate us? So I don't see it. Again, I'm in the minority, but I don't. How will the new laws affect identity theft? To the extent that they are draining the swamp of way too much personal information floating around out there, it has the potential to reduce identity theft. One of the big vectors for identity theft is medical information. So that's the big challenge. And unfortunately, medical institutions are usually understaffed, under-resourced, under everything when it comes to security and privacy. So that's the big challenge. And so in terms of, there's not many opportunities to reduce the footprint of data there because you have to have a lot of medical data to treat the patient. So it's tough. Identity theft from other things other than medical, potentially it could be reduced, but I still think that the problem is there and this isn't going to change it in any material way. Let's go to the next slide. Okay. How is data that is moved around AWS zones and regions handled? Well, the law is really agnostic as to which zones you're moving it. Remember that if you've got it in your possession, you're going to have to adhere to the law full stop. Now, likely if it's AWS or something like it, you're a service provider. So you've got some responsibilities under the law, not as much as you would if you're a pure third party and you can have some autonomy with the data. If you're just providing a service, you'll have some responsibilities, but by and large, moving around zones really doesn't change anything. We used to have to deal with this years ago when I was working with European subsidiaries. This idea that subsidiaries demand that there be a box on the European continent where the personal data was. I don't think that idea is viable anymore, and so I think we worked the problem out using AWS zones to keep it in an EU zone, probably in Ireland. I don't know if that's really a viable way to go about it anymore because of the way cloud computing works, but back then that was how we did it. So the net of it is that AWS or any zone on any vendor really not going to change the dynamic. If you have the personal information of a California resident, if you do, then either you would be treated as a third party or as a service provider, and then work accordingly with the first party. You need to understand what the minimum viable ask is from CCPA. Is it process and governance focused, or does it require technology to ensure the baseline is met? It's both. You always start with process and governance. You know, the old saying we have in consulting about people, process, then technology. Same thing applies here. So it's going to be process, it's going to be governance focused initially. You're going to ask, why do you even have the data in the first place? Are you building a life cycle so that you're getting rid of the data when you don't need it? Are you building security into the life cycle? Are you minimizing what you're collecting? All those fun things. That's a process and a governance question. And you have to really resolve that first. And then ask yourself, okay, great. Technology advances really aren't required. It's just technology, period. Are you finding all the data that you have in your network? Are you finding it in the cloud? Are you searching for unstructured data versus structured? And then the question is, are you classifying it? Are you putting other controls in place to make sure that it's encrypted or obfuscated or what have you? So always start with process and governance first. Fix that problem, fix the people problem, which is always the biggest problem, then add the technology later. If the people won't socialize the technology, if they won't accept the controls and will try and work around them, then it's pointless. Okay, how to tackle the threat landscape that's looming at large to disrupt the automation industry. It's a great question because some companies are really going to take a hard hit. As I said before, ad tech, martech, just any kind of advertising technology in general. If you're a company in that business, it's going to be tough because you're having to do things that you've never done before. But also data brokers as well. Even though it's not an automation industry, data brokers are now having to be identified. The Vermont law that required data brokers to register surfaced about 120 of them, and that was back in February. There's probably more now. We're going to start seeing a lot of folks that we never saw before that worked in the background essentially be uncovered. And so that's going to be a big change for anyone in MarTech, AdTech, data brokerage, and what have you. So a lot of changes are coming down the pike with respect to that. Now, let's go to the next slide. I don't know if we've run out of questions and we'll go to the audience, but let's see. Oh, we got some more here. Differences between CCPA, GDPR, and similar legal frameworks in China and Russia. So here's the challenge. I didn't answer this earlier because China's privacy and security regulations are massive. I literally, whenever I had a question about this, I would find a colleague in China to speak with because it's just not something that you or I really can dig into. Even as a privacy attorney, I wouldn't touch this stuff. Both China and Russia, you have to find local counsel to navigate. China has an extensive list of regulations, and they're not really well defined in terms of the exact things you need to do. They give some things are very vague, some things are a little more specific, but the net of it is that if you're functioning either China or Russia, you're going to have to find local counsel that really knows what's going on. Don't try to do this on your own from the U.S. here. It's just not going to work. It's all very political as a practical matter, and you really need local counsel on the ground to assist you there. Next is relate this to SOC 2 and ISO 27001. I get this question almost every webcast. So let me answer it again. If you have a SOC 2 report or you have an ISO 27K cert, does that make you compliant? The answer is no. Okay, the SOC 2 report is still going to be based upon what you offer up and show, hey, this is our compliance regime. So in terms of whether that compliance regime is working and all that, The SOC 2 will talk about that. And ISO 27K is great to show a cert that you've done all this work. But again, that's evidence. And it's just evidence. It's not a get out of litigation free card. It's just evidence, and you have to keep that in the back of your mind. So the larger question is, how can your organization respond when you're asked to comply with something? If you're asked to comply with a data subject access request, do you have controls in place just to protect the information to begin with? Okay. Do you have technical control? Do you have operational, or do you have administrative control? Okay, that's part of Section 150, which requires those controls to be put in place. And just, you have contracts with your third parties saying, hey, you can't do this with the personal data. You've got very limited things you can do. So the net of it is, it's great to get a SOC 2 report. I don't want to diminish that in any way. I love ISO 27K. Don't want to diminish your cert in any way, but that's just part of the larger picture. You've still got a lot of work to do on everything else. Because if you're collecting data that you shouldn't be collecting, or you don't know where it is in your network, then these things aren't going to help you. And typically, most companies that get broken into, they get hacked by bad guys, the data they lose is data they didn't even realize was there in the first place. And that's a pretty consistent phenomenon that I've noticed over my career. The final question here is, I get these a lot, is how does Fairness technology address X, whatever X might be? Best thing to do, and I have a link to it at my thank you slide here. Best thing to do, it's called salesengineer@sperion.com, and I'll have a, not a link to it, but I'll have a slide for it at the end. But you can just send a note to that, and someone will definitely get back to you. Feel free to CC me if you want, if you think that'll get your question answered faster. But feel free to do that, and they'll be happy to get right on it. So, Abby, let's go to the next slide. Okay. So how to comply, and by the way, I'm leaving time for questions, so if you've got questions, keep sending them in. We'll get to them as fast as we can. How to comply. So create a data inventory. Data inventories, I talk about them on every webcast because, for obvious reasons, you have to know where the data is to begin with. You don't want to be caught with things that you didn't realize were in your own network. Address consumer information access requests. I call them DSARs, data subject access requests, but it's the same thing. Do something to authenticate it. So the question I almost always get is, what do I have to do? I've, in the past, have seen companies just get a copy or a photo of someone's driver's license and a utility statement so that you prove who they are and prove where they live. So that's what I've seen in the past, but you're going to have to authenticate the request. And yes, those authentication data is our personal data, so protect that as well. Destroy that when you don't need it. Do keep a record of the fact that you fulfilled the request. And then package up the information. It's got to be in a portable format. So you think about portable, it could be a CSV file, it could be Excel, it could be Word, it could be a PDF, but something that's reasonably usable by the person. And then those 4 formats are reasonably useful. There's other formats that Microsoft and a couple other companies have come up with. I'll talk about that in a future webinar, but those have some promise as well. And then respond within 45 days, and frankly, get to it sooner than that, because if you run into some problems, you want to leave yourself some wiggle room. So try and get to it within, say, 14 days. That way, if you're having trouble getting the data packaged up, you've got some time to make some changes. Also, create this opt-out or opt-in mechanism. This is similar to what you're seeing already for marketing data. A lot of times now for marketing, you'll get options to check boxes of just the things you want, which is great. You need to do the same thing, though, for just regular personal data, not just marketing. Also, I saw my first cookie the other day that popped up. They gave me different check boxes I could check, which I thought was awesome. I don't know who did that, but kudos to you, because I see cookie banners every day, and at least this one was useful. Also, I mentioned earlier, send a Dear Colleague letter to your colleagues, to your third parties, extolling them to get their ducks in a row for CCPA. And if you really want to keep them up at night, ask them what they're doing about prospective new legislation coming down the pike, say in Washington or Texas or other states that have some really aggressive versions of CCPA. Texas, in particular, has got a very aggressive version. I'll share with you in a future webcast. But the net of it is that send a Dear Colleague letter and keep them up at night. Let's go to the next slide. So, sample data inventory. If you've been on a webcast before, you've seen this. This is a sample of a real inventory. I've changed the name to protect the guilty, but by and large, this is what one will look like. And so the area that has the red box around it, great example of personal information that was really in scope. For, in this case, for the first system, it's an MDM system. So you have the MZ number, IMA, device ID, and ESN. These are all personal data elements. They're all implicated by GDPR and CCPA, not surprisingly. The second one was a DLP system, and so things like the equipment identifier, the user ID, AD credentials, all things that are personal information under CCPA and GDPR. So this is a tiny piece of a much larger data inventory. This took probably several weeks to put together, maybe even longer. Some of these projects were massive. So I know some of these records, in fact, had 100 different systems that were in scope. So it was a big job. That's why you have to start now. And then the next slide is my summary, and then we'll grab as many questions as we can before we wrap up here. This is at the moment the most demanding state privacy statute. More are coming, so just be warned. You will definitely see more, and you'll get webcasts about those whenever new ones pop up. And this is not unlike GDPR. There are rough equivalents. I say rough equivalents. Again, we've got some funny things here that they don't do. One thing that GDPR does do that I like is this idea of legal basis. And the new Texas law that's being proposed for privacy introduces that idea. It doesn't use the phrase legal basis, but that's essentially what it is. So we're going to start seeing legal basis at some point. Right now, we don't have it. In CCPA, GDPR does have it. However, with CCPA, you have a much more direct relationship with third parties than you do with GDPR. So there you go. Guidance will be needed in several areas. I'm trying to be generous here. Guidance will probably be needed for everything. And I know the Attorney General is not keen on that, which is hence why this S561 is up going to legislature, so the Attorney General doesn't have to give advice to people. Because that's part of the statute right now, is that you can ask him for advice, which seems kind of kooky, but that's the way the statute was written. Penalties will likely be severe just because there's an opportunity for a payday for the Attorney General's office and for the state. So don't be surprised to see some severe penalties, bigger than we've seen thus far for GDPR. This is not just likely the first wave, it is the first wave. As I've mentioned a couple times in the webcast here, we've got about 15 states that have these statutes going through legislatures. Probably 2/3 will get through. I think 2 states have already updated theirs this year. I believe it's Massachusetts has updated their 201 CMR, and I believe it is Virginia's updated their data breach. So that's just happened already, but you can bet that there's going to be a lot more. So get started now with data inventory. Don't wait, and don't assume legislature will come to the rescue. They rarely, if ever, do. So that's it in summary and conclusions. There is the thank you and technical questions. You can see in the middle there, salesengineer@Experian.com. Like I said, feel free to CC me if you want to. Don't feel like you have to. That's what I have. Abby, I've got 15 minutes left. We can just start answering questions.
All right, let's do it. The first one is, after reading all the bills and hearing everything that's coming out of California, do you suspect the 30-day cure period will disappear soon?
Yes, I do. If 561 gets through, then the 30-day cure period is gone. And I think that's great, because here's the problem with a cure period. What are you supposed to do? I never understood this. Well, what are you supposed to fix? If the horse is already out the barn, there's nothing to cure. I mean, you can make the argument that you've plugged up the hole or whatever it is that you have in your system, or you fix the problem. If the problem's with a third party, there's no hole to plug. You just have to fire the third party or send them hate mail or whatever it is. I'm being a little bit glib here, but there's not much you can do to fix the 30-day cure period. So I suspect if 561 goes through, cure period is gone. Private right of action, thumbs up, and then AG basically says, oh, I don't have to give you any more advice. So I'm not saying count on that to go through, but don't be terribly surprised when it does.
Great,
Next
thank
question,
you.
Abby.
A number of experts have been pointing out that there are fundamental issues with the drafting of the CCPA. Do you think it is likely that these drafting errors will be fixed soon?
No, I don't. They had a chance to fix them. They passed AB 1125, I'm trying to do this from memory, which was the quote-unquote fix bill that didn't fix things at all. If you want to see all the problems with it, Eric Goldman at Santa Clara University has got a great blog. So if you just Google Eric Goldman, Santa Clara University, and CCPA, he will give you a excruciating list of things that did not go well with AB or SB 1124, 25. They were supposed to fix things. So if you have some time in your hands, go do that. You can see all the things that are wrong. So net of it is they could have fixed it. They didn't. Okay, the technical amendments they did really just fix some very minor things, unfortunately. So the net of it is no, I don't expect any relief anytime soon. Hence why I said don't expect legislature to help you out on this one.
Okay, how does the deletion of information apply to financial record retention requirements?
This is a good one. What you have to do is there's all kinds of exceptions to deletion. So not surprisingly, if you've got a requirement, say you're a broker dealer, you got to hold everything for 7 years, or you've got some other mechanism that requires you to hold personal data just legally, then you've got essentially an exemption right there. Excuse me. If you've got other reasons that are not driven by law, but they're driven by common sense, you want to retain things, for example, because you're concerned that the consumer is going to come back and say, hey, you missed that deposit, I want more money in my bank account or whatever. So if you're essentially trying to do it to protect yourself, then again, I think you're going to get a fairly good exemption from this, just functionally. There's about 10 exemptions to deletion, and unfortunately, as I mentioned earlier, the exceptions almost swallow the rule. So really the stuff that you're going to wind up deleting is stuff that you don't need anyway, in my view. So go through the 10 exemptions, go through it with your lawyer, and I'm not just saying that because I'm a lawyer, but some of these are a little tricky, but go to your lawyer's office and go through them and see which ones you think are most applicable, and get ready if someone asks you to delete information. Say you may be able to say, hey, sorry, we're holding that because of law XYZ, or because we have to protect ourselves from a lawsuit or something like that.
Okay, we received a few questions pertaining to, just for clarification purposes, CCPA only applies to the data of California residents. Is that correct?
Yes, the personal information, as it's called. So it only applies to the personal information, but the list is long. As I mentioned a bunch of times here, when we hang up, go to the statute, go to section 140O, like Oscar. You can see all the different definitions of personal data. I mean, as I mentioned earlier, if the question of what's not personal data, then what is? It's almost comical. The only one that does a better job of making this comical is New York State. Their definition of personal data is remarkable. And every other phrase is including but not limited to, which means that basically anything that identifies a person is personal information. And again, I'm not being glib here, folks. If you go read the New York bill that's floating around, that's their CCPA, it's funny to read. It's just everything's personal data. So your job just got a lot harder.
Okay, thank you. What would be the key security controls or requirements requested or recommended to be CCPA compliant?
Boy, that's a great one. Again, I'm biased towards organizational control. So think about requiring your employees to have background checks. Just keeping bad people out of your organization is a great control. The best control ever invented, and you've heard this umpteen times from me, best control ever invented for information security is an alert employee. So how often are you conducting training? I recommend you have every 6 months, you do either security or privacy to give them updates on what's going on. I can tell you an alert employee will get you out of trouble more times than a firewall will. And I'm not denigrating technical controls, but I got to tell you, organizational ones are just magical and cost effective, and they're just great for preventing bad things from happening. Another control is data minimization. Don't collect it if you don't need it. It's great because if it's not there to steal, then it's not there to steal. You don't have any problems. So really go look at your organizational controls first. Don't rely on encryption. This is the one thing that drives me bonkers here, is that a lot of these state statutes say, well, if the data that was stolen was encrypted or obfuscated or pseudonymized or whatever you want to call it, then you're okay. Here's the problem. How do you know it was encrypted or otherwise obfuscated when it was stolen? That's the problem. How are you going to prove that? And if you're going through the efforts to prove that, you probably already have a pretty good program anyway, quite frankly. So my recommendation is don't rely on encryption. Use encryption. I love it. Don't rely on it. You've got to use different components to be able to protect yourself.
Okay, when they sell loan portfolios to third parties, is that considered as sharing data?
Yes, absolutely. Absolutely. That's personal data. There's no question about it. So if you've got a loan portfolio, you're likely, unless you somehow scrubbed, you've anonymized it, which I don't know how you would do that unless you're just selling a portfolio, prospectively, where you're telling someone, here's the value of it and what have you, it's subject to audit. But at some point, you're going to have to actually put the contact information so you can service the loans. Now, the counter to that is if the data is covered by GLBA, then it's exempt. But here's the problem. Even if it's covered by GLBA, what about all the other information that's not covered? It's in those loan documents. Okay, that's the problem. it's so hard to parse and say, okay, this is GLB data, we're good. This is not, we're not good. Are you really going to go through that effort? Or are you just going to say, forget it, we're just going to just cover everything? That's what I guarantee 99% of the clients that I used to have would have done. They would have just said, forget it, we're just going to cover everything. So that's the bad news, if you want to call it that. You've got more work ahead of you.
Okay, this is a use case question for you, Scott. They said that
Okay.
their HR team has required to retain personnel files for a specific time period. They're asking
Mm-hmm.
when an employee leaves and requests their personal information be deleted, what do they do in that scenario?
You've got to go look at the law because most states have retention requirements. In Washington, I believe it's a full year, and you probably, as a practice, want to hold it for at least the length of whatever statute of limitations are federal and state. So you've got EEOC potential violations that have to be vetted at some point. So however many years that is, you've got tort actions, you've got contractual actions. So that could be anywhere from 2 to 5 years. So the net of it is if an employee requests information, go to the list of exceptions. You'll probably find one at a minimum for the state requirements to hold data, and then look at any other things that might be popping up down the horizon, so things that require you to retain data. So for example, I'm just going to borrow from my e-discovery past life. If there's litigation that's on the horizon, it's likely, more likely than not, litigation is going to happen. You have to hold that data anyway, even if you don't have a hold letter. So that data is then something you can't delete. So what you have to do is whenever you get a request, either have a system that's really well organized as to what qualifies and what doesn't, and then send everything else to your attorney and let them call balls and strikes, because some of these are going to be very gray. But my advice is get legal on the phone, put together a protocol that says if someone requests their data be deleted, then we'll send them this letter saying it's got at a minimum to hold it for a year. And if there's other factors, include that as well, and just generate a custom letter for everyone. It's going to be a lot of work, which is a theme, it seems, for this call, but this is where we are.
Great. How should businesses handle U.S. military since they can be anywhere and maintain residency in any state?
Yeah, that's going to be tough. If there's no way to suss out whether someone's a California resident, then you're going to have to treat everything as California residency, which I know is no good, but I don't know any other way to do it unless you're asking them when you establish a relationship to check a box as to residency and then giving them a chance to change it dynamically. That's a lot to ask. It's a lot of work. So if you don't want to do that, you're going to wind up treating everything as CCPA subject data. Quite frankly, you're probably going to wind up doing that anyway, though, because of all these new state laws are coming out that are the CCPA clones. I think that it's almost inevitable that it's going to be a nationwide standard, kind of a consensus standard, if you will. So the net of it is that if you don't want to track it and who's a resident, who's not, treat everyone under the same umbrella.
Okay, is there an exception for PII contained in backups?
Well, that is the $64 million question. We have the same discussion with GDPR. We also have the same discussion about whether if the backup was encrypted or not, does it change things? My view first is encrypted data is potentially decryptable. Therefore, I still think it's personal data. So put that, and you can find plenty of people who will absolutely disagree with me, but that's my view. In terms of backup data per se, is it subject to it? In theory, it is. Because if you have a disaster, you restore that data. Now that data becomes essentially subject to the law as soon as it's restored. Is it subject to the data while it's storage area? It's difficult to say. You can make the argument that because it's potentially restorable, you should just make it subject to it. You can also make the argument that because it's not available, you can't use it until you connect it to the network, that it really isn't subject to it. I'm going to always lean to being cautious and saying, let's assume everything is subject to GDPR or CCPA and treat it thusly, meaning that you limit who can have access to it, which I presume you do anyway. In terms of having to delete data from the backup, though, if someone asks you, I would only delete it if you restore the backup. I wouldn't dig into the backup just to delete it if you haven't restored it. So that's my view on it. I think that's the reasonable view. But if someone asks you to restore your personal data from backups, I'd say, sorry guys, that's a bridge too far.
All right, I think we have time for one more question. If you're outside of California and you already have data on California residents prior to January 1st, 2020, what are your responsibilities for that data?
If you already have it, depends when you collected it. Remember that the law has 12-month look back, at least at the moment. So I would ask yourself, look at what you've collected in the last 12 months if you can. If you can, then that data is subject to CCPA. If you can't tell what data you collected in the last 12 months versus what you collected previous to that, prior to that, then I'd assume everything is subject to it because you just don't want to be caught. You don't want to be that example, if you will. So my recommendation is if you can parse the data and say, yep, this is the most recent 12 months, great. Here's the problem though, that really requires a project. And I've worked on so many projects and these things just take on a life of their own. So you have to really fight which battles you can win by the end of the year. Because remember, the law goes live at the end of the year. It's the last 12 months of data. Yes, the AG is not going to enforce until July, but the problem is that private rights of action are good from January 1st. If you get a breach, guess what? You're subject to a lawsuit now. So don't be that company. Really get this started now and go through the data and determine what battles you can win before the end of the year.
Great. Thank you, Scott. We received quite a few questions. Apologies to everyone if we were unable to answer your question live on the air. However, as Scott mentioned at the beginning of the webcast, they will be on the Spirion blog within the next few days. And then we'll also send a link to you in the follow-up email. So thank you all again for joining us. Again, the copy of the PowerPoint presentation, a link to the webinar recording will be provided. Thank you to Scott for a great presentation. We hope to see everyone at future webinars. Thanks again. Have a great day, everyone.